Michael Popok with a Legal AF Hot Take. I thought this was a good time before the start of the Donald Trump criminal trial. First time the former president or president has ever been through a criminal trial, to give you the mechanics for jury selection in New York from the perspective of a more than 30-year practitioner of law and trial law. I'm a national trial lawyer. I've tried over 30 cases to conclusion. I've got over a dozen jury trials, and I want to tell you all about jury selection under the arcane rules in New York that you can use as a viewer guide, because it's starting next week, whether Donald Trump and his lawyers like it or not. I know they like losing at the appellate level to try to get a stay. They're now 0 for 3 this week alone, and I'm sure with 1 or 2 business days left before the jury actually comes down, or potential jury actually comes down, they'll try more. But let me give you what's really going to happen next week. How many jurors? What's the selection process? What's the role of the judge? Who goes first? What kind of questions are asked? And the like. Here we go. In New York, let's start at the top. Ultimately, it's going to be a 12-person jury. Yes, the jury has to decide their verdict unanimously. So 12-0 is the burden on the prosecution. If one person holds out or votes for Donald Trump, he loses. Now, there have been over 30 jurors that have taken on Trump cases, and he's lost all 30-0. But let's stay with the facts. 12-person jury. There's up to 6 alternates who get to hear all the evidence but don't get to deliberate, as long as the original 12, if you will, the gang of 12, holds together and are able to get to deliberation 6 or 8 weeks from now. But there are up to 6. Why up to 6? Who decides whether it's 1, 2, 3, 4, 5, or 6? It's Judge Merchan, the trial judge. The trial judge presiding has a lot of discretion when it comes to jury selection. In fact, in New York state courts, in criminal courts, the judge presides over the entire jury selection process. Not quite the same in civil cases that aren't relevant here, but he does. He will sit there and he will be a participant along with the prosecution and the defense team. The prosecution team, Alvin Bragg is the district attorney, but he will likely not be the lead trial lawyer for the case. It will be some combination, I believe, of Matt Colangelo and a couple of other people in that office. On the Trump side, let's get ready to rumble. It's going to be Chris Keiss or Todd Blanche, probably Todd Blanche, lead lawyer, along with Susan Necklace, who unsuccessfully defended Donald Trump's organization 2 years ago and got a 17-count felony conviction against the companies. But she's back. 12-person, up to 6. My guess is there'll be about 6 alternates given the length of the trial. How do they select? The first thing that happens is they bring down the panel. We call it a veneer, the jury veneer. If you get a jury notice and you're getting a jury notice for Monday in New York State Supreme Court criminal, it's a chance you may be sitting in on this trial. But the judge will bring down a group, probably 20, 30, 40 at a time. It depends how large that courtroom is that he's in. They'll seat the potential jury. The jury will be anonymous, not generally, not regularly, but because Judge Merchan, based on Donald Trump's lack of self-restraint, self-control, acting out, breach of gag orders, abuse, and the like, has forfeited his right to have any knowledge about the jury's name and address. Only his lawyers will know that. And we will not know who the jury is. The jury, a sketch artist won't be able to sketch them. Nothing. Anonymous jury, just like the anonymous juries in the E. Jean Carroll case twice against Donald Trump, just like the anonymous jury that'll be held down in Georgia. Because when you got Donald Trump as a defendant, you got to protect the jury. Anonymous 12-person jury. First thing the judge is going to do is the judge is going to determine from his own questioning at the very beginning, without the use of a questionnaire, whether any person has a problem being a fair or an impartial juror in this case. And he'll ask them to raise their hand. Is anybody here for any reason that can't be fair and impartial as a juror, or has any other type of excuse? And the judge on its own, without really doing much inquiry, because he doesn't want to poison or pollute the jury pool by asking these people questions and say, they get up on a soapbox, start giving a speech against the prosecutor or against Donald Trump or whatever, or Michael Cohen or whoever they attack. So he wants to insulate the jury from that. So he'll dismiss those people first cut. Can't be fair and impartial. He'll ask him a little bit about it without getting into details. He'll lop that group off. Everybody moves up in the chairs. Okay, as we try to get to 12. Let's say there's 30, there's 5 people that raise their hands, boom, they're excused without further discussion. A couple people have, their primary caregivers for somebody in their home. They're working mothers that have to care for children. They're the primary breadwinner. They can't take 6 weeks out of their calendar 4 days a week. So it's going to be a 4-day-a-week trial. Boom, they're removed. Now you're left with, from that original, let's say 30, you're left with 20. Okay, you got to get to 12. Now, there's a questionnaire that will be used, a 42-question questionnaire that primarily is developed in consultation with the lawyers by the judge, and they'll ask questions. They're not going to ask them what's their political party, but they're going to ask them things like, do you support QAnon? Do you support the Oath Keepers? Do you support the Proud Boys? It's ways at getting at somebody's political leaning that could infect their ability to be fair and impartial, at least for the lawyers to hear. Right? They're not automatically excused, but they get to hear how these people's minds are put together. So you ask them questions like that. Where do you get your news from? Do you get it from social media? Do you get it from YouTube? Do you get it from mainstream media? Fox News, CNN? These are all proxies for trying to figure out a person. What's their makeup? What's their ken? What's their psychology? What's their emotional state? You can at least lawyers think they can. I've picked many a jury, sometimes with a jury consultant and usually without. And you're looking for any little data point, any factoid that helps you determine whether you want that juror or you don't want that juror and why. So after they go through the 42-question questionnaire, who's ever left standing, let's say, a couple drop off like flies through the questionnaire process, or the judge dismisses them. Now you're down to, let's say, 18 out of that original 30 in my example. Now, the two sides take turns. First, you're picking the jury, the actual jury. Then you're picking the alternates. The process is the same, but it's done compartmentalized. Let's start with this process we call voir dire. Voir dire, V-O-I-R-D-I-R-E, voir dire. It's the jury selection process. Prosecutor goes first, and they get to ask questions. They can ask group questions. Who here, raise your hands, has ever been to a political rally? Who here owns something in their home that has Trump or Make America Great written on it? Raise your hands. And then that lawyer is taking down notes on a big chart. I'll come up there with a big chart. My team will take notes on computer, but I'll have an actual big piece of thumbs up on that, big piece of oat tag, and I'll write my notes with big boxes with a little schematic of the jury box. And I'll label next to it, because of course I'll know the names and the basic information, name, rank, and serial number of each juror, where they live, what's their age, their profession by this point, and the like. And I'll say number 2, okay, and I'll take notes on the chart. You can also ask the prosecution and the defense specific questions. Number 6, was it Mr. Jones, Mr. Garcia, Miss Calabria, Mrs. Goldberg, and you'll ask specific questions based on their answers to the questionnaire or other things. Try to kind of ferret out. Again, you got to be careful you don't pollute the entire jury pool with your questions, because you don't know exactly how they're going to answer those questions. So you ask specific questions. Under the rules in New York, the consolidated penal law, 270.1, each side is allowed to have a full and fair opportunity to question prospective jurors about anything that wasn't obvious before. You get a full and fair opportunity to do that. And Judge Mershon presides over that. He determines how much leeway he's going to give the lawyers. And my guess is, despite him being frequently attacked by Donald Trump and his lawyers because of the notoriety of the case, because of who the defendant is, because of the charges and all of that, he's going to give the lawyers a lot of time for this voir dire question asking process of prospective jurors, right? It's going to be on the long side, not on the short side. I still think the jury gets picked in the first week. I think, I don't think it gets done much quicker than that. Federal court goes a lot quicker, just for those that are court watchers, court lovers. For federal voir dire, jury selection process goes quicker. Judges handle most of it, right? Voir dire is very short, and you can get a jury picked within 2 or 3 days. State court, New York, longer voir dire process, more role for the lawyers to handle the voir dire and get to the bottom and have a full and fair opportunity to ask their questions. Judge presides. That's the big difference between state and federal court, criminal and civil, in picking a jury. So after the prosecution asks all of its questions, we haven't yet picked our jury, Then the defense goes, and they get to do the same exact thing. Group questions and specific questions of jurors, right? And what you're trying to do in voir dire, in state court anyway, federal doesn't really work, is you're almost trying to present your case. It's almost like the beginnings of your opening statement. That's why in the voir dire process, we may learn whether Donald Trump is going to take the stand or not. Now, they may have a placeholder for that. I am sure we're going to hear, do you understand that if my client, this will be from Todd Blanche or from Susan Necklace for Donald Trump, do you understand that the criminal defendant does not have to take the stand in his own defense, that the burden is on the prosecution. And if my client, Mr. Trump, President Trump, whatever they call him, they'll work that out in advance, doesn't take the stand, you can't hold that against him under our system of justice. Do you understand that? Does anybody have a problem with that? That doesn't mean that Donald Trump's not going to ultimately take the stand or that decision's been made. I don't think they announced that. I think they still hold that in reserve, but I am sure you'll hear that as a voir dire question by the defense. We may hear more that indicates, wait a minute, he may really be testifying, or he's definitely not testifying. And we'll report it here on Legal AF and on the MeidasTouch Network. Sick of the one-size-fits-all method, especially when it comes to your erectile dysfunction treatment? Well, good news. Now you've got options with HIMS. HIMS is changing men's healthcare by providing access to affordable sexual health treatments from the comfort of your couch. HIMS provides access to doctor-trusted ED treatment options such as chewable hard mints, brand name treatments like Viagra, or generic alternatives for up to 95% cheaper. The process is simple and 100% online. No uncomfortable doctor's visits. Answer a series of questions on their site, and a medical provider will determine the right treatment option. If prescribed, your medication ships to you for free. No insurance is needed. If ED is getting you down, it's time you join the hundreds of thousands of trusted HIMS subscribers and get treated. Start your free online visit today at hims.com/legalaf. That's HIMS.com/legalaf for your personalized ED treatment options. hims.com/legalaf. Hard mints are chewable compounded products which are not approved by or verified for safety or effectiveness by the FDA. Prescriptions require an online consultation with a healthcare provider who will determine if appropriate. Restrictions apply. See website for details and important safety information. Subscription is required. Price varies based on product and subscription plan. So now you've got the first round of question asking by the lawyers, back and forth, specific and general questions. Then we take a breath and we get to the challenges. This is where you strike jurors based on the information that you just received and what's on my big giant oat tag, schematic of all my notes when I'm taking a jury notes. There's two types of challenges for a jury: for cause, which are basically unlimited in number, and what we call peremptory challenges, which are challenges you can make for no reason or any reason without cause. In a New York State criminal court, you get 10. Each side gets 10 jurors that they can strike for no reason or good reason, bad reason, whatever. And then there's unlimited for cause. And I'll tell you how that works in a minute, with one exception. You can use your peremptory challenges any way you see fit. But if it looks to the other side and to the judge that you're purposely targeting people of color, of a certain race, gender, or ethnicity, you want to get rid of all the men, you want to get rid of all the Black Americans, you want to get rid of all the Hispanic Americans, that then the lawyer or the judge can do what's called a Batson challenge, Batson, comes from a Supreme Court case from the 1980s. U.S. Supreme Court case says you can't do that. And if there's a Batson challenge, the judge will investigate it. And if that is determined to be sustained, the judge will put that person back in the box and will effectively void the peremptory challenge of the person who's done something improper. So that's a little side note, little side teaching on a Batson challenge. Now, for cause is unlimited, meaning if this person is just, a practicing neo-Nazi that attended a rally for Donald Trump, he needs to go. And that'll be a for-cause challenge. Usually that's done by the judge. The judge will say, I'm striking jurors 6, 11, and 9. And now we're down to, whatever we're down to in my math, 9 jurors now. Now you get rid of the for causes, or you raise the issue of these people should go and it shouldn't count against my peremptory. Once you do that, prosecution going first for cause, then the defense goes second for cause. Now you've gotten rid of all the for cause people from your jury panel, the veneer, okay? Then you move to peremptory, 10 aside, unless you have this other issue, the Batson issue. Let's assume you don't. 10 aside. Prosecution goes first. Who's your 10? Right? Who do you want to strike? And then they go back and forth on their 10 apiece until they get to a jury. If they start losing people from this veneer, the judge calls up and has the bailiff bring up more people to fill the box. They're trying to get seats 1 through 12 filled, right? And so they go back and forth on it until they've now exercised and exhausted all of their peremptory challenges, 10 apiece, which is a lot. That's why it takes long to pick a jury. Probably not going to even start the challenge process until day 3, maybe the end of day 2. Because, there's this kind of the opening housekeeping that happens with a jury, welcoming them, telling them the basics about the case that the lawyers have agreed upon with the judge and all of that. And then after they're done with burning their 10 apiece, there should be at least 12 numbered now sitting in a box. Okay. Again, that's why judges will require the bailiff and those that are responsible for jury services to pull up so many potential jurors. There's probably 100 to 150 potential jurors to get down to this 12 plus 6. Because once we finish the process for the 12, then we start all over again with this up to 6 alternate jurors. See why this takes so long? Once they get to 12, the person occupying seat number 1, juror number 1, is the jury foreperson in New York. It's not like in other states or even in federal where you go pick the jury foreperson. That's sometimes one of the first things juries have to do when they start to deliberate is pick the foreperson. It's picked for you in New York. Seat number 1 is automatically the foreperson, regardless of their background. As long as they've gotten through the gauntlet of this process of being selected, they're as qualified as the next person. Doesn't matter of their educational background or their language skills or anything like that. They are the foreperson. And the foreperson has certain duties and responsibilities in leading the deliberations and then effectively communicating with the court if there's notes during deliberations and all that. Once the 1 through 12 are in the box and they are sworn in, there's no backsies. Okay, you can't say, "Oh, I had another challenge left. I want to get rid of 4." You're done. Once the 12 are sworn, they are your jury. And now the parties and the judge moves on to the 6 alternates. I think it'll be about 6 alternates here. And those 6 alternates, once they're picked, same process, 1 through 6, then what happens is they listen to all the evidence. They're there every day of the trial, sitting alongside other jurors. In some jurisdictions, the alternates don't even know they're alternates. They're told later that they're alternates. Here, that's not the case. They know they're alternates. But they got to pay attention because they could be pressed into duty at any time. It's like playing on a baseball team. You're on the bench, but, first baseman could pull up with a hamstring. You're in. And that's what they're instructed. And they got to show up every day on time, just like any other juror. They are a juror. Except at the time when the trial is over, hopefully there's 12 standing. Some might have been replaced along the way by the 6 alternates prior to deliberations. Prior to deliberations, it's relatively straightforward. Juror number 2 gets COVID. They're out. They bring up one of the alternates from the bench. They take that seat. Everybody stays where they were number-wise, and that's the end of it. Even the foreperson. Foreperson can get replaced. Number 1, alternate in, boom, you're the foreperson. That's why it works. And so that'll happen before deliberation. Once deliberation happens, there's a difference. Once deliberation happens, they've been sworn in, they've been sent back to the jury room to deliberate, and somebody doesn't show up or get sick, that person can only be replaced after deliberation starts with the consent of the defense. If the defense doesn't like it, they've just bought themselves and the prosecution a mistrial. They'll have to try this case all over again because they didn't agree. Now, if they agree, but they don't have to have one of the alternates step in, then they're back to 12 and they can continue to deliberate. They can't do it with 11, as in some federal courts or in federal court. It's state court, New York. You got to have 12 after deliberation starts, only with the approval of the defendant to decide whether they're going to agree to that. If they don't agree to that, that means we're doing this all over again with a new trial. Mistrial has happened. No double jeopardy here. We don't have a problem with, they can't try Donald Trump again because they haven't reached verdict yet. But it's going to be another 6 to 8 week delay. There's no other way to do it. You got to dump the jury. You got to start all over again. There's usually a gap of about a week for people to get their acts together, and they're going to start all over again. So, if I'm Donald Trump, you know him, he'll pray that after deliberation, somebody gets sick, he won't agree to the alternate, and they'll have to start all over again. You know that's the strategy. But I wanted you to have it from a trial lawyer perspective, this really important jury selection process, because you'll be watching it next week, not on television or in audio. You'll have to come back to us on Legal AF to give you that explanation on Wednesdays and Saturdays at 8 p.m. Eastern Time on our YouTube channel, and then on audio podcast platforms of your choice. And then the leaders of Legal AF are going to be doing hot takes all along the trial, the beginning of the trial, the middle of the trial, the end of the trial day, 4 days a week for the trial, because they're taking a day off right in the middle, a dark day that we like to call it. And we'll come right back to you. And if you like this kind of content, you can find me as a contributor on the MeidasTouch network under Michael Popok. Look for playlists, look for contributors. You'll see all my 1,200 or 1,300 hot takes, just like this one. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.